Hello everyone, welcome to the part 2 of the week 1 of the Prelims Practice UPSC 2020 series. And in this we'll be taking up 10 questions from our static portion of the syllabus, and that will cover 10 questions from the polity part of our syllabus. Now in this we have been making questions based on the previous year themes. So again we'll be taking the same approach in this video also, and we'll be making questions on important or the first 6 topics that we discussed in the first video. So these will include questions based on the salient features of Indian Constitution, the preamble, and the philosophy of the Constitution. Secondly, there will be questions related to fundamental rights, the directive principles, fundamental duties, center-state relations, and the amendment to the Indian Constitution. So these are first six important topics, and we will be making questions on them. And in this, we will be basing our questions based on the way in which UPSC has formulated its question in these topics. For example, the question related to DPSP or the directive principles will have questions related to the exact provisions of directive principles and also related to important features of these directive principles. And you will be knowing that the UPSC has asked questions on both these themes. So accordingly, we will be analyzing various themes in different parts of the syllabus of Indian polity. Now, besides these 10 questions, you should also practice more questions from these topics, and for this, you can always subscribe to our test series of preliminary examination. Now, in continuation to this series, we'll be taking up discussion of polity in the coming 3 weeks also. So, the next 3 videos in the coming 3 weeks will be based on this portion only. And besides the static portion, there will be current affairs sections also. So, let us start the discussion for this week of Indian polity. So the first question in this discussion related to the static portion of polity, we have taken this question from the first theme that we have identified in the previous analysis. So the first theme was salient features of the Constitution, preamble and union and its territory. So before analyzing this question, let us look at the previous year questions where UPSC has asked questions from this section of the Indian polity. So if you look at the previous year papers, you will find that in the year 2015, there was one question, and in the year 2017, there were 2 questions related to preamble. So the first question that was asked in the year 2017 read, the mind of the makers of the Constitution of India is reflected in which of the following? And in this, the options were provided as to the preamble, the fundamental rights, the DPSPs, and the fundamental duties. Now we know that all these options that are given here include some of the important features of the Indian Constitution. However, to know that what is the requirement of the question, and if you have read about preamble, you will find that the preamble embodies the basic philosophy and the fundamental values on which the Constitution is based. And it contains the grand and noble vision of the Constituent Assembly and also reflects the dreams and aspirations of the founding fathers of the Indian Constitution. And thus, the mind of the makers of the Constitution is reflected in the preamble. Secondly, if you look at this question, it reads, which one of the following objectives is not embodied in the preamble of the Indian Constitution? So the 4 options that are given are liberty of thought, liberty of expression, liberty of belief, and economic liberty. So while reading such questions, carefully look for words like not that are given in the questions. And if you have gone through the preamble, you will find that the word liberty that has been provided in the preamble does not provide for economic liberty. And it provides for the liberty of thought, expression, belief, faith, and worship. Now, as economic liberty is not mentioned there, the correct answer according to the requirement of this question will be economic liberty. So accordingly, you should also have idea regarding the different terms that are given in the preamble part of the Indian Constitution. That is, you should be aware about what is meant by the term socialist, secular, republic, justice, equality, and fraternity, etc. Further, if you look at this question that was asked in 2015, it had created a lot of controversy in that year. It read, which of the following is the custodian of the Constitution of India? Now, while solving this question, many students got confused in these 2 options, that is the President of India and the Supreme Court of India. Now, the point of confusion here was that in the oath of the President, it has provided that President swears to protect, preserve and defend the Constitution and the law. However, if you look at the Supreme Court's functioning, it is the guarantor of the fundamental rights and is also considered to be the guardian of the Indian Constitution. And that is mainly because it interprets various provisions of the Constitution, and also it creates constitutional benches which provide various judgments related to the interpretation of different parts of Constitution. And you might be knowing that the Supreme Court gave the famous Keswananda Bharati verdict in 1973, where the famous doctrine of basic structure of the Indian Constitution was formulated. And hence, in that case, the Supreme Court acted as the custodian of the Indian Constitution. And hence, the correct answer here was D, that is the Supreme Court of India. And this controversy between these two options was settled only when the official answer key of the UPSC was released in that year. And the correct answer that was provided by the Union Public Service Commission was also the Supreme Court of India. So here it should be kept in mind that in such simple looking questions, the options given by the UPSC are at times very confusing. So you should clearly keep in mind various aspects of these options before solving such questions. So accordingly, we have formed this question which reads, which of the following is the guardian of the fundamental rights of the Indian citizens? And the options are Parliament, the President, Supreme Court, and the Indian Constitution itself. Now, as you all might be knowing that the Constitution provides for fundamental rights, and it also provides for Article 32, which in itself is a fundamental right. And this Article 32 provides for various writs which are useful for the enforcement of these fundamental rights. However, as far as implementation of these writs is considered, Supreme Court has the original and wide jurisdiction in this regard. And hence the correct answer here is C, that is Supreme Court. So never get confused by the options like the Parliament or the Constitution and the President that are given in this question. So while reading this section, that is the salient features of the Indian Constitution, the preamble, etc., keep an eye for all the important concepts that are given in these chapters. And that will help you in clarifying things for you. With this, let's take up the next question. Now, the second question here again is based on a term that is mentioned in the preamble of Indian Constitution, that is democratic. And this question has also been designed based on the question that was asked in the year 2017 in the preliminary examination. Now, although the question that was asked in the year 2017 was a pretty straightforward question, because it required us to identify which all terms are embodied in the preamble to the Constitution of India. However, the question that we have found here reads that the word democratic in the preamble of the Indian Constitution signifies which type of democracy. So this question is more interpretation based because these terms have not been used in the preamble directly. So as we all know that the first initial lines of the Indian preamble read that we the people of India having solemnly resolved to constitute India into a sovereign, socialist, secular and democratic republic. So accordingly, the question is based on this term democratic that has been mentioned in the preamble of Indian Constitution. And the options that are provided here are, it includes or it signifies political democracy, social democracy, economic democracy. And we are required to select the correct answer using the code given below. So as discussed clearly in the previous question, one should always carefully look for the interpretations of the important terms that are provided in the preamble of Indian Constitution, and also should be aware about the salient features of Indian Constitution and the concepts that are provided there. Now regarding the word democratic that is provided in the preamble, Dr. Ambedkar in the Constituent Assembly on November 25, 1949 had said that political democracy cannot last unless there lies at the base of it social democracy. And again in the year 1997, the Supreme Court of India had observed that the Constitution envisions to establish an egalitarian social order, rendering to every citizen social, economic and political justice in a social and economic democracy of the Republic. And hence, the word democratic that is provided in the preamble embodies all the three aspects or types of democracy, that is the political democracy, social democracy as well as the economic democracy. And hence the correct answer here is D, that is 1, 2 and 3 only. So again it needs to be stressed that the important terms mentioned in the preamble are extremely important for us from the preliminary examination. And also you should understand the various salient features of the Indian Constitution conceptually and clear your fundamentals regarding those salient features. So after this, let's move to the next question. Now this third question has been formed from another important theme in the polity part, that is fundamental rights. So before discussing this question, let us look at how questions have been asked previously in the preliminary examination related to fundamental rights in Indian polity. So if you look at the previous year questions that were asked from the fundamental rights section, you will find that in the year 2019 there was one question, in the year 2018 again there was one question, and in the year 2017 there were two questions. Now the questions that were asked in the year 2019 and 18 were based on the current affairs that were in news related to the fundamental rights. So the first question that was asked in 2019 reads, which of the article of the Indian Constitution safeguards one's right to marry the person of one's choice? Now this was provided by Supreme Court in one of its judgment that right to marry is one's choice, and that is secured under the Article 21 of the Indian Constitution. Hence the correct answer was B. Now again, the question that was asked in 2018 was related to right to privacy is protected as an intrinsic part of right to life and personal liberty. Which of the following in the Constitution of India correctly and appropriately imply the above statement? Now the right to privacy as a fundamental right was recognized in the famous Puttaswamy judgment. And in this it was recognized as a part of the Article 21, which deals with the right to life and personal liberty. So correct answer here was C. Now the questions that were asked in the year 2017 were of conceptual nature and were not based on the current affairs. So if you go through this question that was asked in 2017, it reads, which of the following are envisaged by the right against exploitation in the Constitution of India? So the first statement is that prohibition of traffic in human beings and forced labor, abolition of untouchability, protection of interests of minorities, and fourth is the prohibition of employment of children in factories and mines. Now, if you read the fundamental rights carefully, you will find that abolition of untouchability is a part of right to equality, and hence it is not a part of right against exploitation. And if you knew this, you can easily eliminate the options A, B, and D. Hence, the correct answer that comes out is 1 and 4 only, that is prohibition of traffic in human beings and forced labor, and the prohibition of employment of children in factories and mines are the part of right against exploitation in the Constitution of India. And if you look at this question that was asked in the year 2017, it created a lot of controversy in that year. And it read, right to vote and to be elected in India is a fundamental right or a natural right or constitutional right or a legal right. Now many of the students got confused between these two options, that is the constitutional right and the legal right. While the other two options, that is the fundamental rights and the natural right, could be easily eliminated. Now if you go through the NCERT of class 11th, that is Indian Constitution at Work of the Political Science, it discusses about the universal franchise and the right to contest. And it reads that the Constitution answers two basic questions about the elections as to who are the voters and who can contest the elections. And in both these respects, our Constitution follows the well-established democratic practices. So these lines clearly identify that the Constitution provides for right to vote and right to contest the elections. And this NCERT further reads that one of the important decisions of the framers of the Indian Constitution was to guarantee every adult citizen in India the right to vote. So this clearly signifies that the right to vote and to get elected is a constitutional right in India. So here it should be understood that you should read the two important sources for Indian polity, that is this NCERT of class 11th, that is the Indian Constitution at Work, carefully, and also one of the standard books for Indian polity, that is M. Lakshmikant. Now after this, let us look at the question that we have framed for this fundamental rights section. So this question reads, which of the following statements are correct regarding the fundamental rights under the part 3 of Indian Constitution? The first statement is that they operate as limitations only on the actions of the executive and the arbitrary laws of the legislature. Second is that they are meant for promoting the ideals of political, social, and economic democracy. And third is that no law that seeks to implement any directive principles shall be void on the ground of contravention of the fundamental rights conferred by the Article 14 or Article 19.
Now, if you read the first statement, it reads, they operate as limitations only on the actions of the executive and the arbitrary laws of the legislatures. So here, if you look at the features of the fundamental rights, you will find that they operate as limitations on both executive and the arbitrary laws of the legislature. However, in some of the fundamental rights, they also operate as limitations on the private people. So this means that they are not only meant for acting as limitations on the executive action and the legislature's action, they are also meant to act as limitations on some of the private actions. So, for example, the right against untouchability is applicable against private citizens also. So, this statement is incorrect here. Second statement reads that they are meant for promoting the ideals of political, social, and economic democracy. Now, the basic purpose of the fundamental rights is promotion of ideal of political democracy only. And this is because they prevent the establishment of an authoritarian and despotic rule in the country. And hence, they are aimed at protecting the liberties and freedoms of the people against the invasion by the state. And thus, they are not meant for ensuring the social and the economic democracy. So, if you go through the constitution, these ideals of social and economic democracy are provided under the directive principles of state policy. And these DPSPs are aimed at creating a welfare state. So, these look after the social and economic aspects of the democracy, while the fundamental rights are aimed at promoting the ideal of political democracy. So, again, this statement is also incorrect. Now, the third statement reads that no law that seeks to implement any directive principles shall be void on the ground of contravention of the fundamental rights conferred under Article 14 and Article 19. So, in this regard, you need to be aware of the important amendments were done with respect to the fundamental rights. So, accordingly, through the 25th Amendment Act of 1971, the Article 31C was introduced into the Indian Constitution. And this Article 31C provided for two important provisions. The first was that any law which was meant to implement the directive principles under the Article 39B and C cannot be held as unconstitutional on the ground of contravention of the fundamental rights which were conferred by the Article 14 and 19. So, any law which was aimed at implementing these directive principles cannot be declared unconstitutional on the ground that it stands against the fundamental rights by the Article 14 and 19. And second provision that was added by the 25th Amendment Act was that no such law can be questioned in the court of law. However, the Supreme Court in the Keswananda Bharti had declared the second part of the 25th Constitutional Amendment Act as unconstitutional. And thus, it again provided for the judicial review of such laws which were meant to implement the socialistic directive principles under Article 39B and C. Now, as a response to the Keswananda Bharti verdict, the Parliament came out with 42nd Amendment Act. And through the 42nd Constitutional Amendment Act, it extended the scope of the Article 31C. And it provided that any law which was meant to implement any directive principle cannot be declared as unconstitutional or invalid on the ground of being contrary to or standing in contravention to the fundamental rights of Article 14 and Article 19. However, this particular change by the 42nd Amendment Act was declared as unconstitutional by the Supreme Court in its Minerva Mills case. So, this particular statement, that is the third statement, was provided by the 42nd Amendment Act. However, this provision was struck down by the Supreme Court in its Minerva Mills case. So, hence, the third statement also is incorrect. And the correct answer here is D, that is none of the above. So, in this regard, you should be aware of the amendments that have been done to the fundamental rights in the Indian Constitution. Further, you understand that you should go through two important sources for Indian polity, that is the NCERT of class 11th, that is Indian Constitution at Work, and also any other standard book related to Indian polity, for example, M. Lakshmikant, etc. With this, let's take up the next question now. Now, the next question is from another important theme in Indian polity, that is directive principles of state policy. However, before discussing the question related to directive principles of state policy, let us look at the way in which UPSC has asked questions in the preliminary examinations related to this topic. So first let us analyze the previous year questions related to directive principles of state policy. Now UPSC has asked questions related to DPSPs in two ways. First is related to the features of the directive principles of state policy, and second are related to the actual provisions of the DPSPs. So for example, this question was asked in the year 2017 and it was related to the actual provisions of the directive principles of state policy which were added by the 42nd Constitutional Amendment Act. The second question that was asked in the year 2017 was related to the features of the DPSPs. Again, the question that was asked in the year 2015 was related to the features or the interpretations of the directive principles of state policy. Further, the question that was asked in 2015 was also related to the features of DPSPs, and again, there were questions in the year 2014, and this question was related to the actual provisions of the DPSPs. However, the question in 2013 was again related to the features of the DPSPs. So this highlights that two types of questions are formed on DPSPs. First is the actual provisions of the DPSPs, and second is related to the features and interpretations of the DPSPs. So regarding the question that was asked in the year 2017, it reads, which principle among the following was added to the DPSPs by the 42nd Amendment Act to the Constitution? So four new DPSPs were added to the Indian Constitution by the 42nd Amendment Act, and in this, the participation of workers in the management of industries was added by the 42nd Amendment Act, and which was added in the Article 43A of the Indian Constitution. Hence, the correct answer is B. Now, the second question that was asked in 2017 reads, consider the following statements with reference to the Constitution of India. The directive principles of state policy constitute limitations upon. First is legislative function and second is executive function. However, it should be noted that DPSPs do not put any limitations on any of the following, that is the legislative functions or the executive functions, and hence the correct answer here was D, that is neither one nor two. Again, the question that was asked in 2015 reads, the ideal of welfare state in the Indian Constitution is enshrined in its. So as we note that the directive principles of state policy ensure the social and economic part of the democracy, while the fundamental rights ensure the political democracy, and hence the DPSPs have the ideal of welfare state in India. And regarding the question that was asked in 2015, which reads that consider the following statements regarding the DPSPs. The first is that the principles spell out the socio-economic democracy in the country. And this statement is correct as we have learned in discussion of previous questions. Second is that the provisions contained in these principles are not enforceable by any court. So as we know that the DPSPs are non-justiciable in nature, and hence this statement is also correct. So the correct answer is C, that is both 1 and 2. Again, this question reads, in the Constitution of India, the promotion of international peace and security is included in. So as you might be knowing that it is included in the directive principles of state policy. And again, the question that was asked in 2013 reads, according to the Constitution of India, which of the following are fundamental for the governance of the country? So regarding this, as we note that one of the features of DPSPs is that they are fundamental to the governance of the country, and hence the correct answer again was DPSP. So by this analysis, we understand that questions can be asked directly related to the provisions. For example, this question, and again, questions can be asked related to the features or the characteristics of the DPSPs. And these are reflected in these two questions. Again, another type of question that was asked in the year 2012 was that consider the following provisions under the directive principles of state policy as enshrined in the Constitution of India. And 4 DPSPs were given. And we were required to identify which of the above Gandhian principles that are reflected in the DPSPs. And if you go through the M. Lakshmikant of Indian polity, you will find that the DPSPs have been categorized into 3 categories. First are the socialistic DPSPs, second are the Gandhian DPSPs, and third is the liberal intellectual DPSPs. And according to that, the first, that is UCC, is a liberal intellectual DPSP. Again, the Gandhian principles are reflected in these 2 principles, that are organizing the village panchayats and promotion of cottage industries in rural areas. And this is because Gandhiji emphasized on the Swaraj. However, the 4th statement is incorrect. Thus, the correct answer was B, that is 2 and 3 only. And accordingly, we have framed this question which reads, consider the following provisions under the DPSPs as enshrined in the Indian Constitution. So the question requires us to identify which of the above are socialistic principles that are reflected in the DPSPs. So if you look at the options that are given, you will find that to promote international peace and security is a liberal intellectual DPSP. And again, to organize village panchayats is a Gandhian principle. And hence the correct answers are 1 and 4. So the correct answer here is C, that is 1 and 4 only. So the takeaway from this discussion should be that many questions have been asked previously in the preliminary examination based on the directive principles of state policy. So you should be thorough with this chapter for the upcoming preliminary examination. With this, let's take up the next question. Now this fifth question has also been designed based on a previous year question that was asked in the year 2017. And we have already discussed this question as to which directive principle was added by the 42nd Amendment Act of the Indian Constitution. Now this question which we have framed reads, which of the following DPSPs was added by the 44th Constitutional Amendment Act? So the new directive principles which are added by the various Constitutional Amendment Acts are important for us from the preliminary examination point of view. And in this regard, you should note that the 44th Constitutional Amendment Act added one more DPSP which requires the state to minimize inequalities in income, status, facilities and opportunities. So C is the correct answer here. Further, you should note that the 86th Amendment Act of 2002 changed the subject matter of Article 45 and made elementary education a fundamental right under Article 21A. And thus, the amended directive principle requires the state to provide early childhood care and education for all until they complete the age of 6 years. So this new modification has been done by the 86th Constitutional Amendment Act of 2002. Further, the 97th Constitutional Amendment Act of 2011 added a new directive principle related to the cooperative societies. And it requires the state to promote voluntary formation, autonomous functioning, democratic control and professional management of cooperative societies, and it has been added in the Article 43B. So you should also learn about those new DPSPs which have been added by these amendments. With this, let's take up the next question. Now the next question is related to fundamental duties of the Indian Constitution, and this is based on the question that was asked in the year 2017 related to the fundamental duties. However, before solving this question, let us look at how UPSC has asked questions related to fundamental duties in its previous preliminary examinations. So if you look at these two questions, these were asked in the year 2015 and in the year 2012. So again, there are two types of questions that can be asked from the fundamental duties. One is related to the actual provisions of the fundamental duties or the actual fundamental duties which have been enshrined in our constitution. And the second type of questions are related to the features of the fundamental duties or the interpretations of these fundamental duties. So if you look at this question that was asked in 2015, it reads, to uphold and protect the sovereignty, unity and integrity of India is a provision made in the. So this is the third fundamental duty enshrined in the Article 51A in the Part 4A of the Indian Constitution, which is related to fundamental duties. And hence the correct answer here is D, that is fundamental duties. Again, if you look at this question which was asked in 2012, it reads, which of the following is or are among the fundamental duties of the citizens laid down in the Indian Constitution? Now there are 4 duties that have been given. So this highlights that you need to remember each and every fundamental duty that is given in the Indian Constitution. So if you have learned all these duties, you can easily eliminate that to protect the weaker sections from social injustice is not a fundamental duty. And hence by this you can easily eliminate the options A, B and D. And hence the correct answer that comes out is C, that is 1, 3 and 4 only. So both these questions highlight that one needs to remember all the fundamental duties that are enshrined in the Indian Constitution. Now if you look at this question which was asked in the year 2017, it reads, which of the following statements is or are true of the fundamental duties of an Indian citizen? First is that a legal process has been provided to enforce these duties. So no such legal process has been provided in the Indian Constitution to enforce the fundamental duties, and hence the first statement is incorrect. Second statement is that they are correlative to the legal duties. So regarding this, you should understand that there is no correlation between the fundamental duties and the legal duties. Now here we should understand that legal duties can be anything, for example, paying of income tax. However, fundamental duties do not have any correlation to these legal duties, and hence the second statement is also incorrect. So the correct answer here was D, that is neither the statement 1 nor the statement 2 is correct. So if you look at this question based on these previous years, it reads which of the following statements is or are correct about the fundamental duties as enshrined in the Indian Constitution. First is that the Parliament is bound to enforce these duties by suitable legislations, which is incorrect because no procedure has been provided for enforcing these duties. And Parliament is not bound to enforce these duties by suitable legislation. Now, although the Parliament is not bound to enforce the fundamental duties, it comes up with laws which are reflections of the fundamental duties. For example, the Prevention of Insults to National Honor Act 1971 prevents disrespect to the Constitution of India, the national flag, and the national anthem. And it is correlated to the duty to abide by the Constitution and respect its ideals and institutions, the national flag, and the national anthem. So, this highlights that although the Parliament is not bound to enforce these duties, it can make suitable legislations on its own. So, the first statement is incorrect. Second reads that they help the courts in examining and determining the constitutional validity of a law. Now, this statement is correct because they help the courts in examining and determining the constitutional validity of the law. And in the year 1992, the Supreme Court ruled that in determining the constitutional validity of any law, if a court finds that the law in question seeks to give effect to a fundamental duty, it may consider such law to be reasonable in relation to the Article 14 and Article 19. So, thus, the Supreme Court's observation of 1992 highlights that these fundamental duties help the courts in examining and determining the constitutional validities of a law. And hence, the correct answer here would be B, that is 2 only. With this, let's take up the next question. Now, the seventh question is related to the procedure of amendment of Indian Constitution and the basic structure. So, before discussing this seventh question, let us look at two previous year questions which have been asked related to the amendments. Now, the first question that was asked related to the amendment of the Indian Constitution was asked in the year 2019, and the second question was asked in the year 2013. Now, this question that was asked in the year 2013 was related to the procedure of amendment of Indian Constitution. However, the question that was asked in 2019 was related to the actual amendments that took place in the Indian Constitution. So, let us try and solve these questions first, and after that, we will attempt the question that we have created based on these questions. Now, this question that was asked in the year 2019 read, consider the following statements. The first statement is that the 44th Amendment to the Constitution of India introduced an article placing the election of the Prime Minister beyond judicial review. Now, this statement was incorrect because such an amendment was done by the 39th Constitutional Amendment Act. However, this amendment was declared unconstitutional by the Supreme Court based on the basic structure doctrine in its Minerva Mills case. Again, the second statement reads, the Supreme Court of India struck down the 99th Amendment to the Constitution of India as being violative of the independence of judiciary. Now, this statement was correct and was in news in the current affairs. And hence, the correct answer here is B, that is 2 only. Now, this question that was asked in the year 2013 reads, consider the following statements. And the first statement is that an amendment to the Constitution of India can be initiated by an introduction of a bill in the Lok Sabha only. Now, this statement is incorrect because any bill for the amendment to the Indian Constitution can be introduced either in Lok Sabha or in Rajya Sabha, and there is no such condition that it can be introduced in Lok Sabha only. And we already know that only money bills are introduced in the Lok Sabha. The second statement reads, if such an amendment seeks to make changes in the federal character of the Constitution, the amendment also requires to be ratified by the legislature of all the states of India. Now, here this term, all the states of India, is incorrect. This is because only 50% states are required to ratify such constitutional amendments. And hence the correct answer here was D, that is neither the statement 1 nor the statement 2 are correct. So if you look at this question which has been framed from the constitutional amendment section, it reads which of the following provisions of the Indian Constitution can be amended by a simple majority of the two houses of the parliament. The first is the representation of the states in parliament. Second is the creation of legislative councils. And the third is conferment of more jurisdiction on the Supreme Court of India. Now, here it is important to understand that the constitution can be amended in three ways. First is it can be amended by simple majority of the parliament. Second is that it can be amended by special majority of the parliament. And then it can be amended by special majority of the parliament and ratification of half of the states. However, if the amendment is done by simple majority of the parliament, then it is not deemed to be an amendment under the Article 368. And this aspect has been asked in this question that is on your screen. So you should always learn that which all provisions can be amended by simple majority of the parliament or by the special majority under Article 368 or by the consent of half of the states under the Article 368. So if you look at these statements, first is related to representation of the states in parliament, and this is related to the allocation of the seats to the states in the Rajya Sabha, and this falls under the fourth schedule. Now this provision is a federal provision and it requires special majority of the parliament and the consent of the states, and that is why it is deemed as an amendment to the constitution under the Article 368, and hence this is incorrect. However, regarding the second and the third, that is the creation of legislative councils and the conferment of jurisdiction on the Supreme Court, both these can be done by the simple majority of the parliament. However, these amendments to the constitution will not be deemed as constitutional amendment under the Article 368, and hence the correct answer here would be B, that is 2 and 3 only. Now in this question, one can get confused by the option none of the above. Now this option has been created because many of us get confused between the amendment under Article 368 and also amendment by the simple majority of the parliament. So many students might be thinking that the constitution cannot be amended by the simple majority in the first place, and that is why they might have tendency to take this D option, that is none of the above. However, it should be kept in mind that the constitution can be amended in three ways, and the first is not included under the Article 368, that is amendment by the simple majority of the two houses of parliament. With this, let's take up the next question. So in this, we should understand that questions can be asked related to the procedure of amendment of the constitution and also related to the important constitutional amendments that have taken place. And in that, the question that we have discussed from the previous years has a question which was based on the current affairs, that is the 99th Constitutional Amendment Act. With this, let's take up the next question now. Now the next question has been framed from another important topic, that is system of government, and we know that there is parliamentary system as well as federal system in India. So let us look at the types of questions that have been asked in the previous years, and also after that we'll try to answer this question. So if you look at the previous year questions, you will find that in the year 2017, the question was related to federalism. Second question that was asked in 2015 was related to the parliamentary system of government. And again, the question that was asked in the year 2013 was also from the parliamentary system of government. So if you look at this question which was asked in 2017, it reads, which one of the following is not a feature of Indian federalism? So be careful about such words that are given in the question, that is, it is not a feature of Indian federalism. So the first is that there is an independent judiciary in India. Now if you look at the features of Indian constitution, independent judiciary is a feature of Indian federalism. Second is that the powers have been clearly divided between the center and the states. This is also a feature of Indian federalism because the powers have been divided in the central and the state list in the 7th schedule of Indian constitution. Again, if you look at the third statement or the third option, it reads, the federating units have been given unequal representation in Rajya Sabha. So this is also a feature of Indian federalism because the states have been given representation in the upper house of the parliament. Now the last statement is that it is the result of an agreement among the federating units. Now this statement is incorrect and is not a feature of Indian federalism. Now in this line, if you compare the Indian federalism with that of the federalism in United States of America, the federalism in United States of America has been created based on the agreement among the various federating units. However, in India, this is not the case. So what you need to understand is that you need to have conceptual clarity about what is meant by federalism. How is Indian federalism different from other kinds of federalism that are prevalent in different countries? Again, if you look at this question which was asked in 2015, it reads, there is a parliamentary system of government in India because The first statement is that Lok Sabha is elected directly by the people. Second is that Parliament can amend the constitution. And the fourth statement is that Council of Ministers is responsible to the Lok Sabha. Now, if you look at the options that are given in this question, these options are correct statements in themselves. However, they do not fit into the context of the requirement of question. And hence, if you look at the option D, it is the best feature of the parliamentary system of government because the Council of Ministers is responsible to the Lok Sabha. Hence, the correct answer here is D. Again, if you look at the question that was asked in 2013, it reads, consider the following statements. First is that the Council of Ministers in the centre shall be collectively responsible to the Parliament. Second is that the Union Ministers shall hold the office during the pleasure of the President of India. And the third statement is that the Prime Minister shall communicate to the President about the proposals for the legislations. Now, if you note that the Council of Ministers in the central government are collectively responsible to only Lok Sabha and not to the Parliament. And by just knowing this, you can easily eliminate the options A, C and D. And hence the correct answer that comes out is B, that is 2 and 3 only. So after going through these questions, it becomes clear that there is a need for conceptual clarity regarding the features of Indian federalism and the features of the parliamentary system of government. And various questions have been asked previously in the preliminary examination, and that is why it becomes an important theme for us in the Indian polity section. So if you look at this question, which has been framed based on the features of Indian federalism, it reads, which of the following features of Indian constitution is or are federal in nature? First is the independent judiciary, second is integrated judiciary, and the third is process of appointment of the governor. Now, if you look at the first, that is the independent judiciary, we know that the constitution establishes an independent judiciary which is headed by the Supreme Court. Now, in this line, the Supreme Court has two purposes, and first is to protect the supremacy of the constitution by exercising the power of judicial review, and the second is that it can settle the disputes between the center and the states or between the two states, and hence it is a federal feature of the Indian constitution. Now, if you look at the second statement, that is the integrated judiciary, you might notice that the Indian constitution has established an integrated judicial system with Supreme Court at the top. And this single system of courts enforces both the central laws as well as the state laws. However, if compared with the United States of America, there is double system of courts in the United States of America. And in US, the federal laws are enforced by the federal judiciary, while the state laws are enforced by the state judiciary. And hence, the integrated judiciary is a feature of the unitary government and not a feature of federalism. And hence, this is incorrect. Third is that the process of appointment of governor, and we note regarding this that governor is the head of the state and is appointed by the President of India, and he holds the office during the pleasure of the President. Further, we also know that the governor acts as an agent of the center, and accordingly, this is also a unitary feature of the Indian Constitution and is not a feature of Indian federalism. And hence the correct answer here is A, that is 1 only. So in this discussion, we have understood that it is important for us to learn about the features of Indian federalism and the features of the parliamentary system of government. With this, let's take up the next question now. Now, the next important theme in the Indian polity that we have identified is the center-state relations. And two questions have been asked in the previous year examinations from this center-state relations topic. And in the previous year examinations, two questions have been asked from this topic. So the first question was asked in the year 2016 and the second question was asked in the year 2013. Now regarding this question which was asked in the year 2016, it reads, the Parliament of India acquires the power to legislate on any item in the state list in the national interest if a resolution to that effect is passed by. First is that Lok Sabha by a simple majority of its total membership. Second is that Lok Sabha by a majority of not less than 2/3 of its total membership. Third is that Rajya Sabha by a simple majority of its total membership. And the fourth is that Rajya Sabha by a majority of not less than 2/3 of its members present and voting. Now, if you look at the center-state relations, you will find that there are 5 cases in which the center can legislate on the subjects that are listed in the state list. And these are first when the Rajya Sabha passes a resolution, second is during a national emergency, third is when states make a request, fourth is to implement any international agreement, and the final and the fifth is during the president's rule. And these provisions have been provided in the Article 249 to 253 of the Indian Constitution. So if you look at this question, you will find that you can easily eliminate the first two because the Lok Sabha does not pass any resolution to that effect. However, it is only the Rajya Sabha which passes this resolution. And in Rajya Sabha, this resolution has to be passed by a majority of not less than two-thirds of its members present and voting. Again, if you look at this question that was asked in 2013, it reads, the Parliament can make any law for whole or any part of India for implementing international treaties. So this question is again from that topic where the center can legislate on the subjects that are mentioned in the state list. And as we know that there are 5 cases in which the center can legislate on the state subjects. And for implementing the international treaties, the center does not require any consent of the states. And hence the correct answer is that D, that is without the consent of any states. Now after this, let us look at this question that we have created from this central state legislative relations. So the question reads, Parliament can legislate on any matter in the state list if Rajya Sabha passes a resolution to that effect. Which of the following statements is or are correct about such a resolution passed by the Rajya Sabha? So the first statement reads that such a resolution should be passed by a majority of two-thirds of the total membership of the House. Now you need to read these statements very correctly and precisely. So if you compare this statement with that of the question that was asked in the year 2016, there is a difference because it requires the majority of not less than two-thirds of its members present and voting. However, this statement reads that it needs a majority of two-thirds of the total membership of the House. So there is a difference, and hence this statement is correct because there is no such provision for the majority of two-thirds of the total membership of the House. Second is that once a resolution is passed by the Rajya Sabha, the state legislature cannot legislate on that matter. Now this statement is also incorrect because this provision in the constitution does not restrict the power of a state legislature to make laws on the same matter. However, in case of consistency between a state law and the parliamentary law, the latter will prevail or the parliamentary law will prevail. So again, second statement is also incorrect because even when the law has been created based on the Rajya Sabha's resolution, it does not seize or restrict the power of the state legislature to legislate on the same matter. However, this state law should not be inconsistent with the central law. And hence the correct answer here is D, that is neither 1 nor 2. So the parliamentary legislation in the state field is one important aspect for us from the preliminary examination in the center-state relations. And in this section, all the 5 cases in which the center can legislate on the state subjects should be clearly understood, and what all provisions are there should be kept in mind for your preliminary examination. With this, let's take up the next question now. Now the 10th and the last question in today's discussion is also from the center-state relations theme. And this question reads, consider the following statements. First is that a law made by the parliament during the operation of president's rule in a state is coterminous with the duration of the president's rule. Second statement reads, statutory grants provided to the states under Article 275 are charge expenditure on the Consolidated Fund of India. And in this, if you compare the Parliament's power to legislate on the subjects that are mentioned in the state list during a national emergency and during a president's rule, you will find that the laws that are made by the Parliament during the operation of a national emergency on the subjects that are mentioned in the state list become inoperative on the expiration of 6 months after the emergency has ceased to operate. However, in case of President's rule, if the Parliament makes a law on the state list or the subjects in the state list, they are not coterminous with the duration of the President's rule, which means that even after the President's rule has been removed, that law will keep on operating. And hence, the first statement is incorrect because such a situation arises only in case of national emergency and when the Parliament legislates on the state subjects during the operation of national emergency. Now the second statement in this question is related to the grant in aid to the states that have been provided under the constitution under the center-state relations. And in this there are 2 articles which deal with such grant in aid. First is the Article 275 and the second article is Article 282. Now, this Article 275 empowers the Parliament to make grants to the states which are in need of financial assistance. And as such, different amount of money can be given to or fixed for different states. And the amount that is given under the Article 375 or the grant that is provided under Article 275 is considered to be a charge expenditure on the Consolidated Fund of India. And hence this statement is correct. And these grants which are provided under the Article 275 are known as statutory grants. And these statutory grants are given to the states on the recommendation of the Finance Commission of India. And regarding the Article 282, this empowers both the center and the states to make any grant for any public purpose. And it was under this article, that is Article 282, the Planning Commission used to allocate different grants for different states for the plan expenditure or the expenditure related to the 5-year plans. So this Article 282 provided for discretionary grants, while the Article 275 provided for statutory grants which are given on the basis of recommendations given by the Finance Commission of India. And hence the correct answer here is B, that is 2 only, because the amount or the statutory grants provided under Article 275 are considered to be charge expenditure on the Consolidated Fund of India. So again, in the center-state relations topic, you should go through different important sections like the parliamentary legislation in the state field, the executive relations, the financial relations, etc. And they can be important for us from the preliminary examination point of view.
So with this we conclude today's video, and for the coming week's video related to the polity section, you should start preparing the next 4 important topics, that are emergency provisions, the President and the Vice President, Prime Minister and the Council of Ministers, and the Parliament budget and the legislative process. Further, for the current affairs section, you should also revise the July current affairs from our Focus magazine. The next videos will be released soon. Stay tuned for more videos.